All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're here in our case 1CA UB22-0042, DYNOMETRICS versus ADES ENRIQUEZ. Each side will have 20 minutes to present your argument. Upon it, you may save as much time as you want for rebuttal, but you'll have to keep track of the time yourself. We have a clock at the podium for that purpose. We are recording the argument both in audio and video, so when you begin your argument, please identify yourself and your client for the record so that we can keep everybody straight when we look at the video or listen to the argument. The argument will come out on YouTube in a couple of days. We've read the briefs, we've conferenced the case so we understand the facts and the circumstances of the case. So when you begin your argument, just start right out with what you want to discuss with us. Counsel, you may begin.
Thank you, Your Honor, and I would like to reserve whatever's left of my time for rebuttal at the end. My name is Spencer Prophet with the law firm of Mayer and Gear, appointed pro bono counsel for DYNOMETRICS, Inc., doing business as Comfort Keepers. And if it's okay with the panel here, we'll refer to them as Comfort Keepers, their business name today. Now, good morning to the honorable members of the court. Counsel gracious enough to be here today to help us wrestle with these statutory construction issues. Unless the panel here has jurisdictional questions they would like me to address up front, I won't spend a ton of time on this court's own jurisdiction and respondents' waiver arguments, except perhaps to briefly establish why those arguments are wrong on this record. I'm here to focus on a different jurisdictional question at this court's request. Was Julie ENRIQUEZ Comfort Keeper's employee at the time her friend, charge, and client passed away?
Before you get into that, could you just clarify what the relationship is with Comfort Keepers and Access?
I'm not entirely positive on the long-term relationship. I do know that Access manages and Mercy Care manage a lot of the care that Comfort Keepers provides because Comfort Keepers' client population is on that end of the economic spectrum. So they, I don't think there is a formal relationship other than Access pays for the care that Comfort Keepers provides through its service providers.
Do they manage the care or do they just manage the employment rules and regulations that go with that?
Your Honor, we're going a little outside the record, so I'm not as familiar with that process. My understanding is that Access, and from what little there is of Access and Mercy Care's involvement in this case, there are periodic case management meetings between the service provider, like Ms. ENRIQUEZ here, and the client and Access, just to make sure that the level of care is up to Mercy Care standards. But I don't have a lot of evidence to that effect, Your Honor.
The question that I have is, if you have an employment relationship with someone, you're the employee, and then the employer dies, whoever payments may be charged to, are you unemployed and entitled to unemployment benefits regardless of who is charged for that.
I'm not positive I understand the question. If I understand right, are you asking why, or?
No, my question is, if you are in an employer-employee relationship and your employer dies, what are the rules that entitle you or do not entitle the employee to benefits, regardless of who ends up paying for it?
Regarding unemployment benefits, Your Honor, it would be a very statutory analysis under the statute. Whether or not an employment relationship existed, first of all, that's almost a jurisdictional question relating to unemployment benefits. And then if a employment relationship existed, whether these circumstances existed under the statute to entitle the employee to benefits. And under those circumstances, it would be a question under the statute that I'm not prepared to analyze at this point. What would happen if an employer passed away? Now, I think I understand the connection to be here, that the employment relationship really is with the client, and most often the client passes away, and that's the termination of the employment by that particular employer. And would you like me to address how the statute anticipates that particular circumstance?
Please, yes.
I think that is one of the reasons, Your Honor, for the exemption, the exception that is provided for these home care workers for unemployment benefits, because that situation arises so often for home care workers where their employment is terminated by the death of their client. That's just a situation that the legislature has chosen to exempt from unemployment, and answer that question up front.
Thank you.
Now,
It's true, isn't it, that at the evidentiary hearing, the representative of Comfort Keepers did not tell the administrative law judge she was not our employee? And if so, have they waived the argument?
thank you, Your Honor. I don't think they have waived the argument. To answer the second part of that question first, it is true that they did not articulate, particularly in front of the administrative law judge, the argument that she was not an employee. They were not represented at the time. These were non-attorney representatives who were dealing with this until the time that I was appointed as pro bono counsel at the appellate level. So they presented the arguments as they understood them. Their understanding was there was a contract signed here where she admitted that she would voluntarily quit when they passed away, and their understanding was there was no unemployment because of the voluntariness of the situation. They understood what was going on up front. They hadn't approached the issue of employment because they weren't sure. Well, they were non-attorneys and probably didn't entirely understand the statutory scheme. Now, the administrative law judge, on the other hand, should have understood that whether or not an employment relationship existed is a threshold issue in unemployment cases, because unless you are an employee of an employing unit, you're not entitled to benefits. And there was certainly enough information in front of the administrative law judge to conclude that there was no employee relationship. The administrative law judge himself summed up the relationship very concisely. You're like a temporary employment agency for home care workers, right? Yes. And I think if anyone had looked at this home care worker exception, the isolated nature of this incident, and whether or not she was an employee, if the department had undertaken that analysis, they would have come to the correct conclusion here. Now, I do say that question is jurisdictional because she must establish that she's an employee in order to recover here. So it is a threshold issue that the department and now the Court of Appeals has to address. And that's one of the reasons it's not waived, is because it's fundamental to Ms. ENRIQUEZ's claims whether or not she was an employee. And the jurisdiction of this court can determine whether or not she's an employee, because that issue was raised at the petition for review level and before, that they did not have control and this was not a situation where unemployment benefits should apply.
What are the factors that we are to consider in determining whether somebody is an employee? And as part of that, if you could point us to where in the record we can find evidence to address each of those factors.
Sure. Now, let me clarify that before you get to the factors, the exemptions would take this particular case out of an analysis of these factors because those specific exemptions apply. We don't even get to these factors. But if you analyze...
So, to make sure I understand, your read of the statute is that because of the nature of the work, this individual could not have been an employee.
That is correct.
Okay.
That's the statutory scheme as it sets up. An employee is someone over whom you have control over the method and means, but notwithstanding that control, these particular classes are not employees, whatever the control. Now, the home care worker, which is the most on-point exception here, applies just based on the nature of the work and takes her out of that consideration of those factors. Same with the exclusion for a isolated engagement. This was isolated. It may not have been short-term. It lasted for a couple years, but everyone knew that this was an engagement for this one client. There were no other clients she could provide services to. It was an isolated engagement.
So is the client the employer?
If there is an employer here, Your Honor, and I'm not sure there necessarily has to be under the statutory scheme, the burden rests on the claimant to establish that she is an employee of an employer. It doesn't necessarily assume that there's an employee-employer relationship in every engagement. It would probably be the client here, Ms. Johnston, who exercised the level of control sufficient for that relationship to exist.
What's your, you referenced the statutory home health care provisions. What's your understanding of that import, that a home health care worker is never an employee of the agency, or is it something else?
Under the unemployment insurance regime, that is correct, Your Honor. The legislature took a look at this class of employees, quote unquote, whether or not they're an employee of the agency, whether or not they're an employee of the client, and the language of the statute does seem to imply that it's the client is the employer because it says whether or not through an agent is employed. That class of workers just isn't a good fit for the unemployment compensation regime because their employment usually terminates with the death of the client.
So if the client was dissatisfied with the care that she was receiving from a healthcare worker, then would the health care worker be entitled to unemployment insurance if the client fired the health care worker?
Potentially. I think that is a potential outcome of well, if you set aside the home care worker exception, potentially. Because of the exception and because of the isolated engagement exception, it wouldn't become an issue because that would take them out of the unemployment system. But to follow your hypothetical, if you'd like, if those exceptions did not work, then the department would have to undergo an analysis of whether or not that client had sufficient control and whether the claimant was able to establish that she was an employee entitled to benefits.
But your point is that hypothetical will never arise because of the exemption.
Because it's messy. I mean, having individuals who are already needing home health care or home care assistance take on the burden of unemployment insurance is messy. The legislature recognized that and decided to exempt this class of workers from the unemployment insurance system.
So it's your argument that we don't need to consider control or who exercised control. The fact that she's a home health care worker takes her out of the unemployment benefit system.
Correct, under that one specific exception.
And under that exception, there are 3 requirements. So I guess maybe that's what we need to have. So it says, so that's number 6 under the definition, the exclusions under the definition of employee. It says medical or healthcare professional. Is that the, oh no, it's the home care.
Number 7.
Number 7. Where in the record, I guess what I'm getting at is how can we confirm your assertion at the beginning of your argument that there is enough in the record for us to reach a conclusion on this versus a need, if we were to agree with you, to send it back for either further findings or further evidence below.
Sure. Even if you're just looking at the proceedings before the ALJ, there was enough in the record between the employment agreement and what was anticipated, the services that would be provided, as well as the testimony, especially in front of the ALJ, talks about what kind of services she was providing to Ms. Johnston. And there are citations in the record, or in the briefing to the specific portions of the record that talks about she was living on site and providing these basic care services. I think the main question under Exception 7 is whether the services Ms. Enriquez was providing fits the description that's in the statute. And there is enough in the record to show that she was providing exactly these sorts of services that are described in the statute.
Well, the lead into number 7 says that the home care services provider has to contract with a person other than as employee. So I guess what you're saying is we don't need any findings on whether or not the contract that uses the employer language was nonetheless other than as an employee. For example, we can get there without the ALJ having made factual findings on that?
I think that's correct.
Okay.
I think the way the statute is set up here, the other than as an employee language can be read a couple of different ways. One is it does seem to assume, as you pointed out, that it's with a person. This is with the person they're providing services for, whether or not through an agent. And it says other than as an employee. I don't think the legislature intended us to go through that weighing analysis that they're avoiding with this exception anyways. Okay. I think they're asking the court here to, it either arises when unemployment benefits are sought from that person, and whether or not this specific exception applies under those circumstances, or other than as an employee might mean if the factors so heavily weigh in favor of finding an employment relationship here, there's a rebuttable presumption. And I'm
Okay.
only got about 5 minutes left on my time. I'd like to reserve the remainder unless the panel
Sure.
has specific questions.
Surely, counsel. Counsel.
Good morning. I'm Heather Stanton for Appellant Enriquez. I'll be splitting my time with the department. We are doing a 15-5 split, so I'll be reserving those last 5 minutes for the department. This case does present an interesting issue of statutory interpretation that in other scenarios would be appropriate for this court's review. But the fact is this is not that case, and this is not that record. This decision cannot be made on the record as it is before this court. In fact, it was noteworthy that during appellant's arguments, it was repeatedly stated that we don't know this. We don't know the relationship between comfort keepers and access. We don't know how other indices of controls work. Who gets to dictate these things?
How do those questions, though, go to this exemption? Where in the language of this statutory exemption do those concerns direct something one way or the other?
I think, Your Honor, you identified the key language that the exemption applies to home care service workers, except or other who contract with a person other than as an employee. So in the plain language of the statute, whether or not this home care services provider is an employee is a threshold issue in determining whether this exception applies. So you could absolutely be a home care services provider that meets all the other descriptions of services provided under that exception, but if you're contracted as an employee, you are still entitled to unemployment benefits. And that's very clear from the language and structure of the statute, that establishing an employment relationship is critical in determining whether or not this exception applies. Had the legislature intended to simply exclude all home care service workers, they wouldn't have included this language saying other than as an employee. It's very clear that the legislature does contemplate that there are going to be home care service providers contracted as employees, whether or not through an agent, that will absolutely fall under unemployment, be entitled to unemployment benefits.
But it looks like we have a lot of questions with no answers, so shouldn't we remand this for the ALJ or the appropriate agency board to find those?
I think that at this point, Your Honor, a remand would be inappropriate. Comfort
Why?
Keepers has had multiple bites at the apple to raise this issue. The first time they even mentioned the issue of whether or not Ms. Enriquez was an employee was at the appellate board level.
But it's true, though, at the hearing with the ALJ himself said, when you were working for Comfort Keepers, were you working as an employee? And Ms. Enriquez said, it's kind of hard to explain because, and then evidently the ALJ interrupted her and said, well, before we get too far into the inaudible, let me ask you some questions, and he went off on a different subject. So the ALJ himself raised the question of whether she was an employee of Comfort Keepers, and then she said it's hard to explain, but before she could complete her answer, the ALJ interrupted. That's how it appears. So isn't it fair to say that the issue was in fact raised but never resolved because of the ALJ's interruption of your client?
I think at most, if we were to say that the issue was raised at all, it actually appears much more that Comfort Keepers from the beginning had been stipulating and agreeing that Ms. Enriquez was an employee. In all of its briefing, when it contested her initial application for benefits, it stated she was an employee, but she was not entitled because she voluntarily quit. At the tribunal level, it, again, did not contest whether or not she was an employee. It referred to her as an employee. It talked about their employment agreement. It talked about how she was not eligible for rehire. All of Comfort Keepers' arguments assumed and effectively stipulated to the fact that there was an employment relationship, and their arguments focused on the methods from which her separation, for the conditions of her separation from employment, and whether or not that was due to any malfeasance on her part.
Counsel, is your position it doesn't matter whether or not she was actually an employee? They are foreclosed from arguing that at this point? We don't, at this point, care what the reality of the situation is? We can't care at this point? Or are you arguing they correctly characterized her as an employee?
I think it's a bit of both, Your Honor. I think they did correctly characterize her as an employee. Although, again, the record is so lean on this that I think it's inappropriate for this court to rule on it, which goes to the second point that had Comfort Keepers not believed that they had an employment relationship with Ms. Enriquez, they could have raised that. And as Judge Kiley pointed out, the ALJ did even start that line of questioning, but Comfort Keepers did not testify regarding any issues relating to whether or not Ms. Enriquez was an employee.
So this is a proceeding, sorry, you go ahead. This is a proceeding in an executive branch, administrative context, which is obviously very distinct from the judicial proceeding. And by that I mean the ALJ, didn't the ALJ have an obligation to inquire into this? So sort of regardless of whether or not the parties properly raised the issue, it is absolutely a threshold issue in all unemployment benefits cases, whether or not the individual seeking benefits was an employee. That's the threshold issue before you get to separation issues or other issues. So shouldn't the ALJ have inquired here? Shouldn't we require the ALJ, this ALJ and future ALJs, to make this kind of inquiry and ensure the record is complete on this sort of thing?
I think there's certainly a benefit for future cases to have what was very much implied here, that the parties agreed that Ms. Enriquez was an employee. I think there would be a large benefit to future parties and to future review by this court to require ALJs to make an express determination on that issue. But I think as applies to this case, the record appears that the ALJ did raise that issue, and ultimately, based on the testimony and evidence that came out that day, found that this threshold matter was met and that really there wasn't much of a dispute about it at all.
Does the record reflect that the ALJ made that finding?
The ALJ, I mean, again, that's, I think that's such a critical point when we're talking about this case at all, right? Like, we're doing a lot of reading between the lines. We're kind of squinting at a few lines of texts to try to determine what should have been a much more robust investigation of these issues. But again, kind of...
Well, if that is the perspective of the case, doesn't that bode toward remanding us so nobody has to squint, that the deciding bodies can take a clear, open-eyed view on this issue?
The waiver rules, serve an important purpose, which is to prevent surprise or having courts rule on issues that were never really presented for the, lower tribunals to investigate. And Ms. Enriquez was never given the opportunity, because there was this apparent stipulation regarding her and agreement that she was an employee. Comfort Keepers' motions and briefings and testimony, they refer to her as an employee. They talk about her eligibility for rehire. They focus on issues with payroll concerns. They at no point discuss these issues, which did not give Ms. Enriquez the chance to present any evidence at that case. But there were so many chances below for Comfort Keepers to do this that a remand would in some ways just be rewarding their negligence. And when it's more than an issue wasn't raised, if you read the record, it appears there's actually not even a disagreement about her employee status up until they go to the appellate
She was asked the question, were you an employee? She could have said yes, and she didn't. She said it's hard to explain, and then the ALJ went off on something else. So it's not accurate to say she was relying on some sort of stipulation or understanding. She herself didn't claim to be an employee.
She also didn't claim not to be an employee, to be fair. And as Comfort Keepers Council has indicated, these are unrepresented parties, unsophisticated parties. Ms. Enriquez was never given the chance to complete her answer. She had that contract, which I think is much of what her confusion would have arisen out of, the one that the appellate tribunal ultimately found to be against public policy, that purported to limit Ms. Enriquez's right to file for unemployment benefits. I believe that might have been the source of her...
Mr. Prophet suggests that home health care workers are, by definition, statutorily excluded from the unemployment compensation system. What's your response to that?
As I mentioned earlier, I do not believe that to be accurate, given the language in that specific exception saying contracts with a person other than as an employee. So I would say that there is first a threshold issue of determining whether or not a home care services provider is an employee or not. And had they been contracted in that way, whether through an agent or directly, if there's an employment relationship under the statute, regardless of how many other of the criteria they make in terms of...
Doesn't this start to get a little bit circular, though? Because what we're working with is the definition of employee and then an exception to it, and what we're saying there in that sort of more strict technical reading of the exception, you're an employee except if you're not an employee, except that's the exception. I think the exception is a little bit more broadly drafted than that. Do you understand what I'm saying about the circularity there?
I do absolutely see what you're saying, Your Honor.
So maybe you could help me with that.
I mean, if I had to guess, I would say that, the legislature is not always perfect in, having statutes hang together.
But in those cases, isn't it our job to do our best to read all the parts of the statute together and to give effect to, for example, here, the entire provision without sort of jumping off the boat in a small portion of the provision as a whole?
Yes, so looking at that statute as a whole and including the specific provision at issue, one of the key points is going to be that I do believe it is accurate that I think many home services providers will not have been contracted as employees, but some might be. And I think the reason there's that circularity and that duplication is to confirm the legislature's intent that while it may be, 9 times out of 10, a home care services provider is not going to be an employee, that 1 person out of 10, if they are contracted as an employee, should still be eligible for benefits. So I think the redundancy is meant to make sure that benefits are provided to those individuals who have been contracted as an employee.
So, in your mind, there is no question that your client is not an employee of the patient, that he's either an employee of Comfort Keepers or not, but there's no other employment relationship other than that.
There's no other employment relationship other than with Comfort Keepers?
Yes.
Yes. Again, the record is just so lean on this issue in terms of the structure of their relationship, how payments were made. It's very minimal. So it is our position that Ms. Enriquez is an employee of Comfort Keepers, and the client that she was serving is a client of Comfort Keepers, while she is Comfort Keepers' employee providing services to that person. But yet again, the record below is just too minimal on that to really make a decision.
Counsel, you noted earlier that on both sides of this issue, there was no legal representation. Doesn't that further bode toward reminding this for appropriate factual resolution?
It could. I think that this court has, in similar cases, one of which cited in our answering brief regarding, statutory exceptions to unemployment benefits coverages, where this court simply affirmed the decision below, chose not to remand, even though it could have chosen to remand the issue to discuss the statutory exemption regarding availability for telework. Instead, this court found that that issue had been waived, and because there is the policy of finding benefits rather than not, the court found that simply because the issue had been waived, even though it was somewhat addressed, things had been mentioned, it wasn't sufficiently raised below to preserve that issue, and therefore remand was inappropriate, and they deferred the decision.
Well, counsel, I have one last question. I understand your argument about the importance of waiver, but as Judge Perkins noted, waiver is a much more important issue in judicial proceedings, and this really was more of an executive administrative proceeding rather than a true judicial proceeding. Would you agree with that?
To an extent, I will say there are quite a few decisions of this court finding waiver exactly in these type of situations. Waiver does still have to do with the fundamental fairness of a proceeding, administrative, judicial, otherwise, and that's a critical part of the process. And to just briefly address, because they do overlap but are slightly different, there is also still, we believe, a jurisdictional issue where the statute grants this court authority to hear appeals, but only for issues that have been raised in the petition for review for the appeals board. We would argue that there is an understanding that these issues raised before the appeals board have to be properly raised and considered by the appeals board. So, whether or not it waived it or preserved it by raising it in front of the appeals board, there's still an issue of jurisdiction of this court being able to hear it because it was not properly raised before the appeals board, and the appeal board did actually not address that issue. I'm going to make sure that the rest of my time goes to co-counsel, so thank you very much, Your Honor.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Jennifer Bloom, and I'm here today on behalf of the Department of Economic Security. I would like to briefly point out, we have not yet addressed the statutory exemption for isolated or occasional services, and I would like to point out that Comfort Keeper's interpretation of that provision is directly contrary to other language in that regulation. So that's in our 6.3.1723C2.
Before we get to that, can I just ask you a background question? What is the relationship with the department with Access and Comfort Keepers?
I'm sorry, Your Honor, I honestly have no idea.
All right. And when the appeals board reviews the decision by the ALJ, do they just review the written decision, or do they review the whole record, including a transcript of the hearing?
My understanding is that they do review the entire record as it exists.
So they would have realized that the ALJ asked Ms. Enriquez, were you an employee of Comfort Keepers? And they would have known that her response was, it's hard to explain. And then she was interrupted.
Yes, my understanding is that the board would have known that. However, I would note that Comfort Keepers also was present and heard that question and had the opportunity to say, actually, Your Honor, no, during their time to present evidence and testimony. So that question being presented, I think that cuts both ways, that Comfort Keepers was there and could have said, no, we don't believe she is, and got that issue squarely in front of the tribunal. If I might return, I just want to point out that isolated or occasional, in subsection B, they're not treated disjunctively. They are treated as together. And what we have here is that if you're performing services on 13 days or more in a quarter, which Ms. Enriquez absolutely was by quite a bit, then you're not doing isolated or occasional work. So we don't believe that that regulatory exemption would apply in this case at all. I'm almost out of time, but I did just want to briefly point out that we do, from the record that we have, the factors that support finding an employment relationship, for the evidence that we have does support that an employment relationship exists, and this court could find that on the existing record. And I also wanted to briefly highlight in the same regulation, subsection E, there are factors that this court should look to in finding that someone is an independent contractor as opposed to an employee, including whether that person is making their services available to the public, whether they're being compensated per job as opposed to per hour, whether they are realizing the profit or loss of the business. None of those factors apply to Ms. Enriquez. None of those factors would support finding that she is, in fact, an independent contractor.
What's your response to the argument that home health care workers are statutorily exempt from the unemployment compensation system?
As Ms. Stanton said, I think if we exempted that language of other than as an employee, we would be rendering that language superfluous, which this, of course, is something that cannot be done. And I would also point to in subsection C, which introduces these exemptions, it again notes that the exemption only applies if the person's not an employee. I would also point out that even Comfort Keepers talked about they have some people who are employed to care for one person, but they also have people who are employed to care for multiple clients. That job doesn't necessarily end when a patient dies because they have more than one patient. And especially given that we interpret these statutes broadly in favor of giving benefits, I don't believe we can interpret that to mean that no home health care worker is ever entitled to unemployment benefits.
Thank you, counsel.
Thank you, Your Honor.
Your argument today. Rebuttal? And Mr. Prophet, if you could begin by showing in the record where Comfort Keepers disputed that they were the employer? Is that in the record?
Your Honor, that doesn't happen until the appellate levels. I will tell you that the proceedings before the ALJ, and I want to clarify briefly, I mean, there's talk about briefing and arguments that were presented at the executive level, the ALJ level, and this was not a complex, extensive discovery, legal arguments type hearing. This was questionnaires submitted by both sides. We have an index of record that, including the appeals level, is less than 100 pages. So I think there might be something to saying that the record here is a little bit slim. Comfort Keepers did not raise the legal argument that it's not an employer until after the hearing, and the ALJ concluded that the termination was not voluntary. They were more focused, frankly, on the voluntariness argument. But the argument was raised at the appellate level, both at the appellate panel and the petition for review. So it's within this court's scope under the statute. Now, the statute providing for the appellate panels, the board's review, doesn't have a limitation language like the one about the Court of Appeals. The panel can look at the record and entertain new legal arguments. They decided not to here, where the record's not entirely clear as to why.
I mean, we may not be here today if your client had said to the ALJ, hey, wait a minute here, we're not really her employer.
That's a possibility, Your Honor, and I think, to Judge Perkins' point earlier, the ALJ, I think, has an obligation to undergo that investigation up front. Whether or not a party is an employee is essentially jurisdictional for the department. If they're not an employee of an employing unit, and that's their burden to establish, there is no unemployment benefits available. So for that reason, Your Honor, this court's reviewing authority is very broad. I would point to some of the cases cited in our brief, Barriga and Simmons, that allow this court to review issues that were raised anywhere within the ALJ proceeding, within the department proceedings, and not just the petition for review. And this one was, in fact, in the petition for review. So it is ripe for review. Now, as far as whether this is a case where it should be remanded, that seemed to be a concern of the panel here that I wanted to address. I think that the record is sufficient, especially to determine that the home care worker exemption applies. There's sufficient testimony and evidence in the record to show that she was doing that kind of work. I think the statutory structure of that statute is critical here because it does deal with the definition of what an employee is.
Well,
so
the agreement between Comfort Keepers and ENRIQUEZ uses the term employment and employee, right? So that certainly suggests that there was an employment relationship.
Your Honor, it would suggest that the unsophisticated parties to that agreement understood that there was an employment relationship and that the reason that she would not be entitled to unemployment benefits, and she was warned up front, I think it should be noted, that she would not be entitled to unemployment benefits, did use those terms in a common and ordinary everyday meaning, but this is a statutory meaning that's different from the common and everyday meaning. And the purpose of this, the balancing factors and the statutory definition, is that it's ultimately irrelevant what the parties considered themselves to be. It's the statute that determines whether or not someone's an employee or not.
Because the facts are so uncertain, shouldn't this be, I know you said that we can resolve that, but wouldn't it be better if the appropriate lower agency did that?
I was about to address that with my few remaining seconds here. I think the record is sufficient to determine whether or not the exception for a home health care worker applies, because that one is spot on. Whether or not this engagement was isolated, and it meets the dictionary definition of isolated, those two, the record is sufficient for those. I think if we're going to weigh I think it's 11 factors of control to determine if an employment relationship exists, there might be some merit to sending it back.
Thank you, counsel. We appreciate your argument today. We'll take this matter under advisement and we'll issue a written decision in due course. We stand adjourned.